Good afternoon, Mr. Chairman, members of the board. My name is Aaron Kapler. I am the county attorney for Bryan County. We are here today on a Section 229 challenge filed by an elector in Bryan County by the name of Jennifer Hilbert. She submitted the challenge on September 19th, 2024, which consisted of an Excel spreadsheet that contained 859 electors in Bryan County to whom she was challenging. It appears that that spreadsheet was obtained from a data broker or data mining website that populates data from other public records. The first spreadsheet that we received was unable to be opened, so we asked her to submit an updated spreadsheet, which she did after hours on the 19th. OCGA 21-2-229 is the statute that we are operating under. That's a Georgia state law. What that Georgia state law does is it allows any elector, which is a registered voter in Bryan County, for instance, to challenge any other elector, which is a registered voter in Bryan County, to challenge the elector's qualifications to vote. Those qualifications are enshrined under Georgia law, which essentially consists of 5 things. 1, a citizen of the United States and a citizen of the state of Georgia. Excuse me. Over the age of 18, a citizen of Bryan County, and then otherwise qualified to vote, which generally means you're not a convicted felon or have any other disqualifying event. The burden of this hearing is on Ms. Hilburn to present evidence and to prove on an individualized basis that the people that whom she has challenged are disqualified. It is not the burden of the challenge to prove. It is the burden of the challenger to prove. If she fails to present that evidence, then her challenges should be dismissed. The board today is sitting in what's called a quasi-judicial manner. What that means is this board is going to determine the facts based on the rules of evidence and the evidence presented by Ms. Hilburn, and then to the extent the person who is being challenged has evidence, that person may present evidence also. This board is going to determine those facts based on that evidence and then apply the law, which would then indicate whether or not the person is qualified to vote or disqualified to vote based on those factors I already delineated. The law requires this hearing. Section 229 of the Georgia law does not give this board discretion to not hold a hearing. It does not give this board discretion to dismiss these challenges out of hand. The statute says shall. Under Georgia law, shall means must, which means this board must have this hearing, and this board must give Ms. Hilburn the opportunity to present her evidence, and this board must give those people who have been challenged the opportunity to present evidence as well. It is not discretionary. As I mentioned earlier, these are individualized challenges, not systematic challenges. That means federal law that governs, it's called the NVRA, does not apply here because that federal law applies to systematic challenges, not individualized challenges. The documentation and the evidence that this board can consider must comply with the rules of evidence. That means, in short, hearsay, unauthenticated documents, website printouts. Those documents standing alone is not going to be sufficient evidence to sustain a challenge to a qualified elector. In addition to that, it's important to note that federal law indicates that simply a change of address form submitted to the United States Postal Service, that also is not sufficient evidence to sustain a challenge. And data broker websites, printouts from websites, and other documents like that, those are also considered to be hearsay and unauthentic unless the challenger has other documentation or other admissible evidence to show this board it is sufficient to sustain the challenge. At this point, my recommendation for the board to proceed is to call Ms. Hilburn and ask her to present her evidence on an individualized basis on each person that she has challenged. Mr. Chairman, I believe you have a spreadsheet along with the board that outlines the order in which these cases are brought. and she should come forward, be prepared to present that evidence. One final point, two final points. First, just like a court proceeding or any other evidentiary standard, this board was not permitted to investigate the facts prior to today. You were not permitted to pull county records and verify yourself. That's not the function of the board. The function of the board is to consider the evidence today, make the decision based on the evidence today. Lastly, we have received some information that Ms. Hilburn may not be here today.
What's her?
Irrespective of that, we would not cancel the hearing despite receiving that information for a number of reasons. The law requires the hearing to be had, and number two, in the event we tell people the hearing may not be going forward because she has indicated she's not going to appear, and then decides she does, the electors would be prejudiced by not having the right to be heard. So that is why the hearing is going to proceed today. And Mr. Chairman, I will turn it to you to call the first case.
All right, so the first case on the agenda, the magnifying glass here. Justin Gary Adams. Now, is Ms. Hilburn here today? Jennifer Hilburn, are you present? Someone want to check the hall, see if she's here?
Jennifer, here. Hey, Jennifer. Jennifer.
Mr. Chairman, it appears that Ms. Hilburn is not present for this challenge that she brought under Section 229. Under the law, that means she did not establish the necessary evidence to prove her challenges. And so at this point, I believe, Mr. Chairman, you should take a motion on the challenges brought by Ms. Hilburn.
Anyone want to make a motion?
I make a
We
motion
all do.
to deny all the charges brought against the voters.
And I'll second that motion. All in favor? I know there's a lot of you here, and we appreciate that. We have a lot of meetings. We have meetings every month, and usually no one comes. I've been on this board since 2014, I think. That being said, y'all are obviously interested in the process. We're going to have 3 openings for the board January 1st. If you're interested, you can go to the Bryan County website. There's a little section where you can click and say, I want to apply. It has all those different positions that are open for the different boards, not just this one. So I advise you all, if you're interested in the elections process, want to become a part, you can do that. Also, the rest of the meetings are usually pretty dry. We usually do citizen public comments at the end of the meeting. But I think, I think we'll go ahead and do that now, because I think, reading on Facebook, I know y'all have a lot of other things you want to do. So I think we're going to go get the list of people that signed up to speak. And if you want to speak, or if you don't, that's fine. We'll go through them. Otherwise, free to go.
Can she call us back here?
Excuse me?
Can she call us back?
So, Section 229 does not indicate or does not put a prohibition on successive challenges by an elector, unfortunately. That's how the state law is written. So theoretically, another person could bring another challenge to any elector registered to vote in Bryan County.
Is there a deadline?
What kind of recourse do we have against her?
Yes.
Federal law is with you can't challenge or throw somebody off the rolls within 90 days of an election.
That doesn't apply in Section 229.
That's disgusting.
So what's our recourse?
That federal law doesn't apply in Section 229. Hold it down.
Unfortunately, the board is not in a position to give you guys individual advice as to what your recourse is against this person. If you're seeking recourse, I advise you to talk to another attorney. We're just concerned about validating the electors in Bryan County, terminating and running the elections. So Again, I know a lot of you are upset. I read Facebook as well. So again, if you want to go, you can. Like I said, it looks like about 10 people have signed up to speak. First one is Bonnie Cortez.
And Mr. Chairman, if I could put one more thing on the record before public comment begins, and I believe I said this, but if not, I'm going to make very clear that I did. Ms. Hilburn was properly served with the notice of this hearing via hand delivery to her residence. So she has been served, she knows the hearing is today, and so her failure to appear is acknowledged.
Well, whatever the mark was on these individual, the 859 voters, will that be taken off now and they're clear? Because there was a mark.
I'm not sure what the mark would be.
I mean, they're targeted. Will that go away now?
They were prevented to vote.
So the Board of Elections and Registration today denied all of those challenges. So to the extent anything was caused by the filing of the challenge, that would be removed.
Aaron, I'm sorry, could you repeat that
Motion
for my?
to, yeah.
Yes, I'm sorry. So the question was raised about marks that may be on your election registration. Okay. I'm not sure what those marks are, so I can't comment on an individualized basis. But practically, if this challenge that was brought resulted in a mark being applied on your registration, the denial of that challenge ought to remove any mark contained on your registration.
And in the event we go to vote and they deny us to vote, what's our recourse?
You're not going to be denied to vote based on this challenge.
Sir, I have a question. What do we need to take now? Like we were told to email in the form, or do those steps still need to be taken by everyone who received the letter, or if this is disallowed today, does anything need to happen by all of us in the room?
So these challenges were denied. So if you have not submitted additional documentation to the county, you do not need to on the basis of this. However, just to be clear, Georgia law does require you to update your registration timely if you have moved within the county or otherwise. So if you still need to update your registration, please do so.
Thank you.
I have one question. I spoke with you on the phone earlier today. I told you that I had to drive up here from Brunswick to leave work early. You said that the board would request for you to do an investigation.
Yes, sir. So
Didn't get hurt.
the commentary, the question was that was posed is there any recourse available to the challenger as a result of this challenge? And my indication was, to the extent the board directs me to do an investigation on that, I'd be happy to do that. But that's up to the board to decide. Yes, ma'am.
My question is, everyone here wanted to face their accuser. How come she has not, you don't know why she's not here, but why isn't she forced to be here? When she's the one that filed it.
She wasted a lot of our time, a lot of the state law.
She wasted the voters' registration office time too, that's what they told her.
This has been an enormous undertaking to go from the receipt of the challenge to compiling the data, serving the notices, getting all this ready was certainly an enormous undertaking.
And a cost.
And it cost.
Bryan County.
The result, the immediate sanction or outcome for her failure to appear is that her challenge is what it is.
Well, since it's because of her that all this got mailed out and the Bryan County's gonna have to absorb that cost, she should have to reimburse.
Yes.
County.
Ms. Hilburn, is that what needs to happen by those that have been challenged?
So just to be clear on that point, I represent the county. I do not and I cannot represent any of y'all on an individualized basis on any of these types of things, right? So to the extent you feel like you have been wronged individually by the challenger, I would encourage y'all to investigate that recourse yourself.
Well, if you represent the county, then you can sue her to pay the county back.
My direction is provided by the Board of Commissioners and the other boards whom I represent. It's up to them to decide if I do an investigation and then what that investigation is. I don't know what the outcome would be. Right, I can't prejudge what any investigation might determine.
All right, and
Yeah, Mr. Chairman, if you want me to, yeah.
I think what we'll do is we're going to ask you to look into that and just let us know whether or not we do have recourse and report back to us.
Yes, sir.
Let's get back to public comment. We have a list of people that signed up to speak. First person on the list is Bonnie Cortez. Bonnie here?
Yes.
Okay.
Okay.
Just come up and state your name.
I'm Bonnie Cordes,
Okay.
and I'm here to contest the challenge, but it seems like the challenge has been denied, which is very good. Thank you very much. I just want to say this has been very time consuming for my husband and myself, and it's very traumatic. I mean, I've been voting for a long time, and no one has ever challenged me. And I think it was horrible of this person to do that. And I can't say, whatever recourse I have, I will have to seek legal counsel. But I certainly hope the board really takes it to heart for what this woman has done. So anyway, that's all I have to say.
Well, thank you.
Thank you very much.
Michael Smith.
Yes, just briefly, like everybody here, I think I'm frustrated. I'm frustrated with this entire process and that we all had to be here today. I'm frustrated that our state apparently passed a poorly thought out law that required and allowed somebody to do this to all of us, and by all of us I do include you as well, forcing you to be here and to deal with that. I do ask that the board, through whatever channels you have, push and let the state know that this happened and that they need to look at a way to not let this happen again, whether that make adjustments to the law to make some of the changes that people wanted to have happen today, or to open some gates for recourse for those of us who have had this done to us, because obviously this is unacceptable for us. And that's really what I want to say. Thank you.
Thank you. Sean Murphy.
Is it okay just to speak from back here, or do I need the podium?
I think we need to be able to pick up on the microphone. These meetings are.
I'll walk while I'll talk while I'm on the way.
Oh, we can wait.
Because I think people can hear me. You know, I want to thank the board, and it's good to see everybody that wants to vote. That's a good thing. But I want to thank the board and the county attorneys, for your efforts in this. I know it's been a pain for y'all, and everybody is frustrated. But this is clearly an attempt to suppress voters. It's just cut and dry. It's an attempt to suppress voters. The way I read 229, the elector has to be a resident of the county or the municipality or the city. But my question is maybe the law needs to be amended so that they in real time can prove their accusations and prove not from the NCOA or homestead exemptions or any of the other places. And that's where we do need to contact our county officials. And I'm talking elected officials, I'm sorry, state officials. Because the law does need to be amended, because I don't believe the purpose of the law is to be used to weaponize the political system. And that's what this law has done. And I am for this law. I think the law is well placed, it's just poorly written, where this foolishness can take place, which only adds to the hostile sentiment we already experienced in the political arena. And we are just pawns in that game. And so I like to thank the board. Everything got covered that I was going to say because the person that's supposed to be right there is not here, just like I assumed that was going to be the case. You know, let's raise a lot of smoke and mirrors and noise and not sit at the table and stand your ground. That's the type of person that must be. But that's my opinion. But I just want to thank the board, and I'm glad everybody wants to vote.
Patty Hewitt.
Good evening. Thank you for having me here. And thank you all for the work that you do on an everyday basis. This is not an easy job, and especially in today's environment, so thank you very much for being here for us. My name is Patty Hewitt. I also want to disclose I'm the Democratic nominee for Congress in the 1st Congressional District. However, I am here to represent the voters of Bryan County. I am a resident of Bryan County. My concern about this kind of action is that we can see the results of these laws now in real time. We can see them right here in our community and how it affects our community, how important it is that voting is to our constituents. But I also think about all of the 859 people that could not be here today. And that's something I'd like to advocate for. That as you consider your actions when these kind of challenges are brought to you, to offer as much transparency to us as a community as you can. To make sure that if a voter is challenged, they have an opportunity at a reasonable time in their estimation to come and bring their documentation. Many people, I'm sure, are very anxiously at work or in other places where they could not be here, and they do not know what's going on. They do not know their status of their voting. You can see that these kind of challenges do not promote a free and fair election, but instead create opaqueness. And that's something that you can help us with. I urge you, as you begin to move through this and think about any legal ramifications with this, that you keep the public informed as to what is happening. This has had a tremendous impact on our community. We want to make sure that we are doing, and you are doing, everything you can to ensure that these invalid challenges, and if they were valid, clearly Ms. Hilgrim would be here if they were valid. She would defend what she has brought. But so one can assume that perhaps the intent of this was simply to do this, right? And to cause the kind of concerns, anxiety, stress among voters. And that is not going to create trust in our voting system. What you do has everything to do with trust. These actions will not promote trust. So I ask you again, as you move through, considering the ramifications of this, that you make sure that the public is kept well informed, and also consider about holding any public hearings like this at varying times, so that more of the public, more of the working public in particular, can come. Thank you very much.
Patton?
I pass.
Pass. Joanne Dickley?
I don't pass. I want to start by thanking y'all as my predecessors did, and this is a little back work, but I'm going to read something I wrote in the wee hours because I was still traumatized by this. Why should my mother, a World War II veteran who's resided in Richmond Hill for 58 years, have to validate her right to vote? This is what really bugs me. Yes, I'm speaking for her, but she's right back there because she has voted every election she's been physically able to. Targeting, I think, Republicans, supporters, because we had a Trump sign in the yard, and terrifies her. She's afraid something's going to do something to her. It's got to stop. People who exploit the law for the manipulation and restriction of voting rights should be brought to justice. I don't know what we can do about it, but something needs to change. Maybe I'm not as upset as y'all are, but I've been upset for 2 days. My mother is as I said, a World War II veteran. She is proud of her right to vote, and she served to protect us and protect that right. Now she must fight again to prove she is worthy to vote. This isn't right. She shouldn't have to be doing this. I shouldn't have to be working in them. And 4/5 of my family that reside at 105 354 Ford Avenue is included on this list. Yet, we were never contacted. We never received the letter. We found out only Tuesday from the Good Samaritan that we were included in this and required to submit proof by Thursday. I would have never expected this underhanded escapades to have
Bryan County. You know, I was shocked by it. Why, what's this, 2 days for me to get all this together and make sure that my children, my mother, and my daughter-in-law can vote? I'm so glad that the outcome is what we found today. I am so glad, because I'm shaking now, and buddy, the mean part hasn't come out yet. The mad part's out, and I'm just, I would pray that we can all work, you, sir, and everyone else here, and yourselves, in making this something of the past. Whether it be some change in the law, even if we got to start at the local level and work our way up, we've got to do something different. Where my 102-year-old mother does not have to come to the courthouse when she's normally asleep by 4 o'clock. This crap should not go on. But I thank you for your time, and I did bring something to show everybody. I'm so proud of it, I'm going to show you. That's my mother in her World War II.
Follow that.
To you, say your full name.
Yes, my name is Denise Palumbo. I am a new resident of Bryan County. I've been here almost 2 years. December will be our 2nd year. And I have had the same name for 28 years. I have voted since I've been 18. And when I had my daughter, and she was able to walk, I actually took her to the voting booth every single year until she actually voted for her first time. My daughter did not receive a challenge. My husband, who also lives at the same address, did not receive a challenge. However, my son did. And as you can imagine, I was livid. And that's the most polite way I can put that somebody was challenging my right to vote. We moved here from the Northeast, if you can't tell, because I'm starting our business down in the Savannah area. We bring in lots of containers to the port. I'm opening 2 distribution centers, one 790,000 square feet, another 1 million square feet. And we're basically transitioning all of our jobs down to this area. So as you can imagine, we have a house of our dreams. We love where we live. You all are so nice. Thank you so much for making that determination. However, I want you to take into account my son. My son is 24 years old. Getting my son to vote is a challenge. He doesn't think it's important. And when he received that challenge in the mail, he went, well, they don't want me to vote anyway. So please take that into account, and please do have the district attorney go after this person and anyone else who does this kind of thing. Because I've had this right since I was 18, which was a little bit ago. And I've enjoyed this right, and I've voted in every single election, including local elections. So thank you very much for your time, and please do consider that this law should be written correctly, especially because younger voters just need a reason not to show up. Thank you.
Kathleen Korsick.
Hi, my name is Kathleen Korsick. A lot of people have already spoken about pretty much what I was going to say, except everyone keeps talking about how the law needs to be changed, but they're not being, I don't think, specific enough. There needs to be a repercussion for someone who challenges, like maybe illegally, maybe inappropriately, maybe whatever the word is, bigoted, whether they, obviously obviously did it on purpose when you're challenging a regular people. So you're doing it on purpose and you're doing it for a reason. Someone had always mentioned they feel like this group has been targeted. So if I can ask, it just with confidence, just everybody, just do me a favor and close your eyes, just for privacy. For privacy, close your eyes and raise your hand if you're a Democrat. Thank you. White mate.
Last name gives me Valley from the League of Women Voters.
Oh, Malloy.
Malloy, sorry, like I said, I was having trouble reading it.
All right, so good afternoon. We'll just call in. My name is Chastity Malloy, I'm president of the League of Women Voters of Coastal Georgia. One, it just pleases me to see so many concerned citizens who are passionate about the right to vote and are very concerned about the ability to have unlimited challenges in Georgia, which is the law. Just to name it here, Senate Bill 189, which allows for unlimited challenges, and that's why you have so many folks here today who are dealing with this situation. I agree with everyone. No one should have to validate the right to vote. I'm 100% with that. And I also believe that as a county, you all should be concerned with that and the impact that that clearly has on the folks that are here today and the folks who cannot be here today to challenge this, to speak and challenge their challenge, essentially. I know it sounds a little bit convoluted, but that's what they're here to do, to prove that they are registered and their vote is valid. A question and a recommendation to you all. I'll start with the question. It seems as though you all, to hear this, would have had to have had probable cause before hearing this challenge, and it must have been reasonable. There was a special call meeting just before this one. Was there probable cause in the challenge that was presented?
That was the determination that was made.
It was probable cause, so she has cause.
Yeah,
Just
the
to
way
clarify.
the letter was written, if the allegations that were made and the stuff that was presented, if it was true and there was testimony, admissible evidence pursuant to the rules of evidence that would have had to been presented, making a probable cause of submission to the board, the rules of evidence doesn't necessarily apply. There's a lot of, we couldn't consider anything, we're not allowed to go and look at anything outside the confines of the hearing. But believe me, it bothered all of us on the board. I probably know personally 100 of the people that were on the list. I've represented them. I've done the real estate closings. I know them, and I did not have a right, and the law did not allow me to go in and say, that's BS. We just tell Joanne Bickley not to come today. It bothered me that we had to go through this process and come here today and have people miss work. People get upset. People get...
Right.
I mean, it bothered me, but yes, the way the letter was written, it appeared that there was enough basis to go forward and set the hearing.
So she
Whether or not the evidence could have been presented, I don't know.
Do I want to defer my time, or how does this work here?
Yeah, if I may interject, Mr. Chairman and members of the board, the probable cause standard or the probable cause baseline is in section 230. Section 229, which is what these challenges were brought, automatically goes to the hearing. And as you indicated, Mr. Chairman, we're not allowed to do an additional investigation prior to the hearing itself. And so section 229 requires that upon receipt of the challenge, this board is required to take action, which is what we did when you authorized me to send the notices, et cetera, et cetera.
Thank you, Mr. County Attorney, for the clarification. I just wanted to make sure that everyone here was clear on that too, that there was, you're saying, probable cause for these challenges to be presented.
The way the letter was written.
The reasons are fine, you know, we just want to know, And then my recommendation, just to move us forward, is that there needs to be a procedure for handling these challenges. This is something, I'm a resident of Chatham County, but again, President of Coastal League of Women Voters, and so we see this happening everywhere. And like I said before, first point, no one should have to validate their right to vote. And so, you know, I just think that as a county, if you're concerned with the amount of people that have shown up here today, which is very typical, as I understand it, then you would be willing to perhaps work with us and other organizations or agencies to make sure that we can make this process a lot simpler, and also perhaps even eliminate the need for folks to come in here like they're doing and taking their time and making these very passionate cases and pleas to come in and verify their right to vote. So I just think there needs to be something that can happen. I know the state board is an entirely different agency, and you're beholden to, you know, their rules and their governance. But at the same time, if you see issues like this causing a problem in your community, I would ask politely that you stand up and speak to the folks that are here speaking up today. Thank you.